Good evening, Judge. Good evening, classmate. My name is Grace Bation. My report is about the case of Dusit Hotel Nico versus Renato M. Gabonton of 2006 case, GR number 161654, May 5, 2006. Provisionary employment. Provisionary employment shall not exceed 6 months from the date the employee started working unless it is covered by an apprenticeship agreement stipulating a longer period. The services of an employee who has been engaged on a provisionary basis may be terminated for a just cause or when he fails to qualify as a regular employee in accordance with reasonable standard made known by the employer to the employee at the time of his engagement. An employee who is allowed to work after provisionary period shall be considered a regular employee. Article 281 clearly states as a provisionary employee can be legally terminated either first for a just cause or second when the employee fails to qualify as a regular employee in accordance with the reasonable standards made known to him by the employer at the start of the employment. Nonetheless, the power of the employer to terminate an employee or probation is not without limitations. First, this power must be exercised in accordance with the specific requirements of the contract. Second, the dissatisfaction on the part of the employer must be real and in good faith, not fake, so as to circumvent the contract or the law. And third, there must be no unlawful discrimination in the dismissal. In termination cases, the burden of proving just or valid cause for dismissing an employee rests on the employer. The facts of the case. On November 21, 1998, respondent Renato M. Gabonton was hired as a chief steward in petitioner Dusit Hotel Nico Food and Beverage Department. He signed a 3-month provisionary employment contract until February 21, 1999, with a monthly salary of $25,000 on March 24, 1999. Robert, director of its Food and Beverage Department, informed Gabonton that the latter had poor ratings on staff supervision, productivity, quantity of work, and overall efficiency, and did not qualify as chief steward. Gabonton requested another month until April 22, 1999 to improve his performance, to which Robert agreed but allegedly refused to sign the performance evaluation form on March 31, 1999. On notice of termination of provisionary employment effective April 9, 1999, on the above alleged around was served on Gabonton on April 12, 1999. He filed a complaint for illegal dismissal and non-payment of wages with prayers for reinstatement, full back wages, and damages, including attorney's fees, and complainant's prayer for damages is hereby dismissed for lack of concrete evidence. The issue, whether or not the respondent was validly dismissed on the ground of failure to meet the standards of the satisfactory performance made known to him at the time of his engagement, held no. In the absence of any evaluation or valid extension, we cannot conclude that the respondent failed to meet the standards of performance set by the hotel for a chief steward. At the expiration of the 3 months period, Gabonton person had become a regular employee. It is an elementary rule in the law on labor relations that a probationary employee engaged to work beyond the probationary period of 6 months as provided under Article 21 of the Labor Code or for any length of time set forth by the employer. In this case, 3 months shall be considered a regular employee. This is clear in the last sentence of Article 281. Any circumvention of this provision would put to no doubt the state about protection for labor. Since respondent was not dismissed for a just or authorized cause, his dismissal was illegal, and he is entitled to reinstatement without loss of seniority rights and other privileges, as well as full back wages, inclusive of allowances and to other benefits of their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual reinstatement. The petitioner presented copies of checks and the corresponding voucher in the amount of 6,995.19 to prove that the respondent had been paid his remaining unpaid salaries on May 26, 1999. We have no reason to disbelieve said payment since the respondent failed to refute his matter before the Court of Appeals and before us. Therefore, the instant petition for review is denied. The decision of the Court of Appeals is CAGR SP number 73296, which reversed the resolution dated September 24, 2001 of the National Labor Relations Commission, is affirmed with the modification that the order made for payment of unpaid salaries is deleted. Thank you and have a good day.
Created using Powtoon.